Well, this summer could see an unusually high number of farmers utilizing the prevented payment option as weather conditions continue to delay those planting conditions. Of course, joining us now to review the legal issues associated with prevented planting is Roger McEowen. He's with the Washburn University School of Law. Roger, thanks for taking the time to chat with us on this very timely topic. First of all, give us an update on the prevented planting payments this year and what you're hearing.
Well, I'm hearing exactly what you just reported, and that is we're probably going to see perhaps a record number of farmers make prevented planting claims just simply because they can't get in the field, or it's too late in many instances to get in the field. We still have significant areas in Nebraska and northeast Kansas and northwest Missouri that are just flat out underwater. The Missouri is spilled out over its banks, and I just flew back into Kansas City a few days ago, and it's just unbelievable from the air what you see. So I think we'll probably see a great deal of prevented planting payment claims made, and of course, to get the MFP payment, you have to plant this year. So that's going to be an important consideration for a farmer to go through the economics of their decision.
Well, Roger, what are some of the legal and regulatory issues associated with prevented planting payments that we need to keep in mind?
Well, there are both legal issues and there are regulatory issues. Of course, anytime you get into a government program, you will invoke the government regulatory process and the administrative process. But I think it's also important for farmers to understand that when I look at the cases on this, one of the things that really trips up a lot of farmers is that they make a claim and they end up being the only farmer in their particular area to utilize prevented planting payments. That's not a good thing. So it's important to know what neighboring farmers are doing, because obviously what the insurance company is going to look at, and ultimately any court, if it gets that far, is why were you the only person in the area to make a claim? Other people were able to plant. So that's a big issue. And then, of course, you get into all types of regulatory and administrative issues in terms of the procedure and the process you have to go through.
Roger, do you maybe have an example for us?
Yeah, in fact, there are a couple of recent cases, one out of Nebraska not too long ago. And when you get into prevented planting issues and there ends up being a dispute with the insurance company, there's an arbitration clause in the agreement that you sign. You're going to have to go through arbitration in most situations. Well, in the Nebraska case, the farmer missed the deadline for trying to vacate or get rid of a crop insurance arbitration award that went against them. So you got to watch your statutory timeframes. In a more recent case from North Carolina, the arbitrator's award was in favor of the farmer, and in fact, the insurance company had admitted that they had made a mistake on the claim, and the court went ahead and awarded triple damages to the farmer. The insurance company appealed that and said, well, wait a minute, court, you were actually acting outside of your jurisdiction. You have to go through the Federal Crop Insurance Corporation and their set of rules. And on appeal, that was what the court said. So not only do you have the USDA administrative process, you've got the Federal Crop Insurance Corporation administrative process that can also get invoked in these situations. So it really gets tangled up pretty quickly with a lot of rules. And so you really need a good lawyer by your side helping you through these situations where there are disputes.
Roger, as always, thank you very much for the timely information. Again, Roger McEowen, he's with the Washburn University School of Law, joining us today on the phone from Topeka, Kansas.